Appeal in the matter of Competition and Market Authority and BMW, the king on the application of Volkswagen Competition and Market Authority.
Yes, Mr.
May it please your lordships, I appear for the Competition and Markets Authority with Mr. Jones and Mr. Howe to my left.
Yeah.
Ms. Abraham appears for BMW with Mr. McIntyre. Mr. Kennelly appears for Volkswagen with Mr. Pobjoy.
Yeah.
The court has listed Ms. Abraham's application first for reliance on her supplementary bundle. I don't think it needs to detain the court. Can I just indicate that we didn't formally consent to it because we, in accordance with the practice direction, we didn't consider it as necessary for the court to read it. But if the court wants to read it, of course, we have no objection. And so can we move on to the substantive appeal? Thank you. As the court is aware, these appeals concern the proper construction of Section 26 of the Competition Act, and the procedural routes by which the two appeals have been litigated are slightly different. But the purposes of the appeals, for the purposes of this appeal, they raise identical facts. So the Volkswagen and BMW undertakings are multinational undertakings. The parent company in each undertaking is based in Germany, and the parent company, its common ground for the purposes of the appeal, does not have an office or place of business in the UK or hold documents here. However, both undertakings have subsidiary companies which are incorporated in the UK and which do carry on business here. And the question for the court is a question of law, namely, can the CMA compel the Volkswagen and the BMW undertakings to produce documents and information held by them which are relevant to an investigation being carried out by the CMA, even if those documents are held by the German parent companies outside the UK. That's the question of law that arises. And the details of the CMA's investigation in this case are not material to the points of law, save as to one point, which I'll show you briefly, and we can see that in the core bundle, if you could pick that up, please, at tab 21. This is the penalty notice served on BMW, and if you could go to page 316, please. And it's really the very last sentence of paragraph 2.1. The CMA has reason to suspect that important aspects of the arrangements were agreed abroad before being implemented in the UK. Now, Section 26 confers a power on the CMA to require any person to produce to it specified documents and information for the purposes of conducting an investigation into suspected breaches of the Chapter 1 and Chapter 2 prohibitions in the Act. And the question for the court is whether any territorial limits should be implied into that power, and if so, what limits? And this is, as you'll have apprehended, a question of enormous practical significance for my clients, for the CMA. It's common ground in this appeal that the substantive provisions of the Competition Act have extraterritorial effect, and that this was recognised by Parliament when it enacted the Competition Act.
Well, the Section 26 is, if you like, subsidiaries Section 25.
That's right.
And in turn, Section 2. So they all have to be read together.
Quite so, my lord, and that we say is an important point because Section 2 and Section 18, which of course I'll come to, define their territorial scope, and they're plainly extraterritorial. And Section 25 then enables the CMA to investigate all breaches of the Act, so including breaches which are committed abroad but implemented into the UK. And so an important point in this case is if that's the power that's been expressly conferred on the CMA by Parliament under Section 25, how on earth is it supposed to exercise it if it can't get documents from entities abroad which are committing breaches which then are implemented in the UK? And we say that is a critical point in this appeal.
Well, it's power to investigate, but it doesn't have any teeth.
Precisely so. Precisely so. And that cannot have been intended by Parliament. So when one is looking at the wording and the scope and the purpose of the statutory scheme, that, in our respectful submission, is a critical point. And of course, the Competition Act was modelled on EU competition law. That's not in dispute. And it had been clear since the very early days of EU law, and of course the court will know this, thinking back to the dye stuffs case and the wood pulp case, The Articles 101 and 102, which were then, of course, 85 and 86, applied to prohibit conduct which was carried out in third countries, but implemented in the EU. And in wood pulp itself, the wood pulp producers, which colluded on price, were based outside the EU and colluded outside the EU, but their conduct was an infringement of Article 85 because it affected, they sold into the EU and it affected the price of the wood pulp they were selling into the EU or the European community as it then was.
That's why you have the language of section 2.3, which incorporates implementation.
Yeah, precisely.
But those words are not in section 25. So 25 doesn't, you don't have to have reasonable grounds for suspecting implementation to trigger the power to investigate. It's broader than section 2 in that respect.
Yes, but what section 25 says, and we'll come to this, I'm going to go through the Act with some care. Section 25 plainly confers power on the CMA to investigate all breaches of the Act, including those which are implemented into the UK in accordance with the language of section 2.3. And it couldn't be otherwise. If there were the only way of investigating these breaches, it's the CMA that's charged by the statute with investigating, detecting, investigating and punishing these breaches. And so, of course, the CMA has to have power to detect and investigate and punish breaches which are within the substantive scope of Section 2 and 18. And as my Lord the Chancellor put it to me, if it's got the power's got to have teeth. It can't have an illusory power with no means of getting documents or looking into the facts.
Is the question in law really whether the power in section 25, which is the umbrella power, is to be treated as commensurate, at the least, with the prohibition in section 2?
We say it plainly is, and that's an important point in the case.
Is that really
plainly
the question?
Well, we say that's a very important question in this case. So it is commensurate, we say. Plainly power was conferred on the CMA to investigate all breaches of Section 2 and 18, including those committed abroad, implemented in the UK. And once that's recognised, once one recognises that that's the scope of Section 25, then of course that important purpose of the Act would be frustrated if the CMA couldn't obtain any documents from undertakings situated abroad. And it's obvious why the EU and the domestic rules have this extraterritorial reach in our respectful submission, because as the court below held, as the tribunal held, economic entities will more often than not be international and straddle borders, and the competition regime would be extremely easy to evade if it were possible for entities simply to act abroad, keep all their documents abroad, and then commit these serious breaches which affect consumers in the United Kingdom. That's why Section 26 permits the CMA to compel specified documents and information for the purposes of its investigation from any person, and this power is not subject to any express territorial limitation. And the CMA's case...
Any person as well?
Any person.
Not just any person in the UK or...
No, there's no territorial restriction. It's any person. And any person includes undertaking. We see that from Section 59, expressly includes undertaking. And so we say there's no express territorial limitation. That is telling in itself. But the tribunal was wrong to find that it's subject to an implied territorial limitation, because if it were, as I say, this would defeat a key purpose of the Act. Now, the CMA doesn't rely solely on the purpose of the Act, although of course that's of critical importance. The tribunal's construction of the Act is inconsistent with its express wording, and as I say, I'm going to come to the Act and look at it in some detail. But Section 59, as the court will have seen, defines any person to include not just persons as defined in the Interpretation Act, but also undertakings. That's the purpose of Section 59. That's what it says on its face. And undertakings, as the tribunal correctly found, are not territorial in nature, but frequently straddle borders. So that's another indication that Parliament, in formulating the power in terms of undertakings, was not intending it to be a power which is just limited to the borders of the United Kingdom, because undertakings are not by their nature entities which are necessarily confined to a single country. And of course that legislative choice makes eminent sense in circumstances where the substantive rules are themselves applicable to undertakings in terms, as the court well knows. The undertaking is the unit of account under the Competition Act, just as it is under EU law. Now, having found correctly that any person in Section 26 must include undertaking because of Section 59, and that a notice under Section 6 can be given to an undertaking, the tribunal then went wrong. It then reached a conclusion entirely at odds with that finding, namely that the notice is only binding on those parts of the undertaking that comprise natural or legal persons who are present in the UK. And that, of course, completely defeats the purpose of Section 59 and the wide terms of Section 26. Now, the respondents to this appeal, it's interesting, do not seriously seek to defend the tribunal's reasoning, the reasoning of the courts below. And indeed, we can see that from Mr. Kennelly's skeleton, if we can pick that up from the core bundle, tab 8, page 99. And if we look at paragraph 63, the last sentence, this is what Volkswagen say. So they refer to, so you can see the highlighted, the underlined words just below halfway down. That's the tribunal's, or the court, High Court, it's sat as both, I'm going to call it the tribunal. The tribunal's reasoning may require any legal or natural person within an undertaking, provided that they're within the jurisdiction of the UK and that at least one legal or natural person within the same undertaking has been validly notified. So that's the tribunal's reasoning. And we say, no, that's wrong, and I'm going to come to the tribunal's judgment. But undertaking means undertaking. It's to be treated as a single person. That's the whole purpose of Section 59. Volkswagen say that is a strained and artificial reading of Section 26(1). The provision must either be read to apply to legal or natural persons only, which is the respondent's position, or to undertakings, which was the CMA's position, but they say that that has problems, which we say is wrong. We'll come to that.
Yeah.
But they say the middle ground compromise, has identified by the High Court, has the effect of illegitimately rewriting the statute. Well, we agree with that. So no one here is seriously seeking to defend the reasoning of the tribunal. The difficulty for the respondents is that their preferred construction of any person in Section 26(1) also involves rewriting the statute, as I'll come on to show you. Apart from anything else, it disregards Section 59, but it's also...
saying, well, in the case of this section, person just means a natural person, doesn't mean an undertaking.
That's what they say.
And that's just...
It's just wrong. It's just...
Section 59. If you ask yourself the question, what is the paradigm situation in which Section 59 has extended person to mean undertaking, one might have thought this is it.
My Lord, precisely so. And as I'm going to show you, I'm going to come on to show you this in the Act. Section 59 contains other provisions which expressly show that Parliament had Section 26 in mind. So it's wrong to say, they're wrong to say that it only involves a company or an individual. That's not what the Act says. That flies in the face of the express wording of the Act. But also, as I'll come on to show you, their argument is based on a straw man. The straw man being as follows. They say, well, any person in Section 26 can't include an undertaking because an undertaking is an artificial construct and you can't do things to an undertaking and an undertaking can't do things. And they say for that reason, a Section 26 notice can't be given to an undertaking. It has to mean a company or an individual. But what I'm going to show you in the Act is that that is not how Parliament has proceeded. Parliament has in multiple provisions provided that an undertaking can take specific legal steps or have specific legal steps done to them. And I'm going to show you that when we come to the Act. So the premise for their argument is simply wrong. And let's also be clear about the consequences of the respondent's argument. What it would mean is that large corporate groups such as BMW and Volkswagen can establish themselves in the United Kingdom and conduct a huge amount of business here, as they do, infringe the competition rules to the detriment of UK consumers by some agreement that happens, say, in Germany or overseas, ensure that all relevant documents are held by the parent company in Germany, and thereby frustrate any investigation by the CMA. That simply cannot have been Parliament's intention when enacting this legislation. And if it were correct, the CMA's powers would be vastly inferior to that of the European Commission investigating infringements under the EU competition rules. And I'm going to return to that point to make it good on the authorities. But the headline point is that the Commission does have power to require an undertaking in the EU to produce documents and information held by the undertaking outside the EU. That's the headline point. And indeed, it's done so in this case. That's the irony of all of this. The suspected infringement in this case is also under investigation by the European Commission. And if I can ask you to pick up the supplementary bundle, please, behind tab 2.
Is that proposition in dispute? I mean, I think we've probably all been in cases, and I certainly remember a few where my clients were based in the US and had to produce documents.
So I think what Miss Abraham says, I'm not sure about Mr. Kennelly's stance on this, but I do recall that Miss Abraham says, oh yes, well the Commission's got power to ask, but they don't have power to compel because they can't impose a penalty. I think that's her position. I'm getting nods. And we say, no, that's not so, because what the Commission can do and does do is impose penalties on the part of the undertaking in the EU, which it can enforce.
But there's another issue which we're interested in, which I'm sure you'll all address, is the extent to which issues relating to implementation are relevant. So, for example, if you're trying to enforce a notice against an undertaking or a company or a representative of an undertaking in the US or in Germany or in China, wherever, you have to use such powers as you have under either Brussels regulation, if you're still there, or equivalent provisions, international law. Doesn't mean to say it's perfect. You've just got to do what you can internationally.
Yes.
But is there any problems which arise in relation to implementation? Are they relevant to sort of cast the light backwards on interpretation of the Act?
Well, I'm going to come to that, my lord, but just in brief summary, of course, the respondents say, oh, well, you can't enforce these provisions effectively against people abroad, so you can't. The Act provides for a penalty to be imposed if a Section 26 notice is not complied with, and they say, well, you can't properly enforce that against people established abroad. But we say that can't. That's not correct, because one can enforce it against.
Assume for the sake of argument it's difficult or complex. Is it relevant from our perspective in construing the Act to say that enforcement outside of your own jurisdiction might or might not be difficult? So, for example, if the Federal Trade Commission or the Department of Justice in the US wants to implement or enforce a cartel which has been operated throughout Europe, as they have done in the past, is that relevant to cast a light upon the initial interpretation of the Founding Act?
We say in these circumstances, no. And can I just give you the brief answer why? Because, of course, the court will be aware that the substantive provisions of the Act, so let's forget for the moment about Section 26, but think about a final decision establishing an infringement against an undertaking. Of course, that may be difficult to enforce against a company in Asia or an American entity. It might be difficult to do it, but it doesn't mean that the power doesn't exist in the Act. And there is, for all intents and purposes, no material distinction between enforcement under Section 26 and enforcement of the substantive provisions. So I don't want to overstate the point of law, because there are some cases where the statute is not clear, where the courts have said, well, it's actually impossible to enforce, and then that might be of relevance to the interpret. That might be an indication that Parliament didn't intend the Act to have extraterritorial power. So I don't want to overstate the point. But in this case, that doesn't apply, because one can see quite clearly with the substantive provisions that they have to be enforced as best they can, and they are against.
Just in terms of, in a sense, analytical framework.
Yes.
The first question is Parliament's intent. What's the combined effect of sections 2, 25, 26 and 59? If one comes to a conclusion that that is a complete system, then you presumably say there's no room for any implication or inference to be drawn. It's only if there is a gap in the system that Parliament intended to exist that there is any scope for applying a presumption which has an interpretive value. Otherwise, the Act just simply tells us what it tells us, and we know what Parliament's intended.
Yes, can I take it in stages under the case law? Because I think that it's a very good question with respect, but there are lots of points in there, if I can say. It's a complex question. And so what we say in summary, but I'm going to kind of walk through it in my submissions, is we say that the fact that the statute contains no express territorial limitation, but on the contrary expressly provides for these substantive provisions to be extraterritorial. We say that that's an extremely telling point.
Well, you say that. I mean, one of the things we want to analyse closely with you is the effect of Section 25,
Yes.
which is the umbrella power for Section 26. Because on its face, it does have territorial limitations, constraints built into it.
Well,
I mean, you know, you would say extraterritorial.
Yes.
Might be said on the other side of the courtroom territorial, but that may be the answer if Parliament, if the proper inference to be drawn from the umbrella power is that it's extraterritorial. Is there scope for any further limitation?
Well, my lord, we say that Section 25 mirrors or is intended to provide the power to enforce Section 2 and Section 18, which have extraterritorial effect as stated in those provisions. So they're not.
But I mean, Section 25 has territorial limits, and you might say extraterritorial.
Yes.
They're built into Section 25 too.
Yes.
On the language.
My lord, I don't want. Can I come because I'm going to come through it all in turn, and it may just be more logical if I can deal with it as I'm going through the Act, if that's acceptable.
Show something in supplement.
I just wanted to show you this. So it's in. So it's supplementary bundle 2. Supplementary bundle tab 2, page 49. Can you see? I'm not going to read it out. There's a highlighted point in green. Can I just ask you to read that because it does indicate what the Commission has done in this case.
Yeah.
And so if the respondents are right, then what we have is a position where the Commission can investigate this suspected infringement of the competition rules, and indeed could investigate it even if all the documents were in the UK by seeking information. They can seek information from the BMW undertaking wherever those documents are located, as I say, including documents in the UK. And if it finds an infringement, the Commission can make a decision requiring the infringement to be brought to an end and penalising the undertaking and thereby protecting consumers in the EU. But on the respondent's case, the CMA is hamstrung. If the documents required to prove the infringement are held in Germany, as is very likely, the CMA cannot take equivalent action to protect consumers in the UK. Now, you'll have seen that the respondents argue that if the CMA is right about the construction of Section 26, this will result in all sorts of practical difficulties. And we say that that's completely overblown. And the fact that it's overblown is evidenced by the fact that the Commission quite happily sends requests for information to undertakings, and none of these practical difficulties arise. Now, of course, if there is some uncertainty in any particular case, if an undertaking says, hang on, there's 91 subsidiaries across the world, you can't mean all of them, then of course they can engage in discussion with the CMA, which will have to act reasonably, and ultimately the CMA is amenable to judicial review. If it takes some, if it
That's the point, because it's because Section 25 is the umbrella power.
Yes.
If what's being questioned is there is if the undertaking or part of the undertaking has reasonable can say you don't have reasonable grounds for suspecting that these entities within the undertaking
That's right.
have either are engaged in conduct which has the effect of affecting competition within the UK, or they don't intend to do that. Well, then they can JR, can't they?
Yes, and if a penalty notice, if actually the CMA presses ahead and a penalty notice is applied, they can appeal that on the merits. So there are safeguards, and it's simply what we used to call an interorum argument to say, oh well, this is all hopelessly impractical. Now, what I propose to do is make my submissions as follows. I want to start with taking the court to just 3 authorities, because in my respectful submission they do frame all of the issues which arise. They are KBR on the presumption against extraterritoriality, RVL, which concerns the issue of legal personality and Parliament's power to create new legal persons, and the CJU's judgment in Aalborg, Portland, which shows that the Commission has power to require an undertaking to produce a document, and explains why that's important in terms of effective enforcement. Then I was going to take the court through the relevant provisions of the Competition Act, and as I say, I'm going to do that with some care. That's going to take me some time. And it's critical, really, for 2 reasons. First, because the presumption against extraterritoriality, on which my learned friends rely, is a rule of statutory construction. So it's axiomatic that you need to scrutinise the statute to work out to what extent the presumption arises and whether it's rebutted. And secondly, because of course the court needs to work out, the issue in this appeal is what does any person in section 26 mean? And that must, again, entail an examination of the terms of the statute. Thirdly, after that, I'm going to take the court to the judgment below and show the key reasoning and why we say it's wrong. And fourthly, what I'll do, and it may be at this stage I can do it quite swiftly, is draw together the CMA submissions under both grounds, including by reference to a very small number of additional authorities. So if that sounds like a practical way forward, I'll start with the three authorities and KBR.
Okay.
KBR is at Authorities 2, tab 59. So if you're working in hard copy, it's the penultimate tab.
Sorry?
It's the penultimate tab of Authorities Bundle 2, tab 59.
59.
Yes. And if we could pick it up, please. Paragraph 1 summarises the facts, which are pretty straightforward on page 1257 in the bottom right-hand corner. So the Serious Fraud Office invited this court to proceed on the basis of the factual position at the date of the divisional court hearing on the 25th of July 2017 at a meeting in London. The SFO gave a notice on behalf of the director of the SFO, pursuant to section 2.3 of the Criminal Justice Act 1987, to an officer of the appellant company, KBR Inc. The notice required KBR Inc., a US company, to collate material held abroad and produce it to the SFO under criminal penalty for failing to do so. KBR Inc. didn't have a fixed place of business in the UK and had never carried on business in the UK. KBR Inc. sought to quash the notice on the ground that section 2.3 of the 1987 Act does not have extraterritorial effect. Contended there was no jurisdiction for the SFO to issue the notice requiring the production of material held by it outside the UK. And this is obviously a case on which my learned friends rely because the Supreme Court found, overturning the judgment of the Divisional Court, that indeed that statute did not have extraterritorial effect. Now, if you could look at, if you could go to the next page and look at paragraphs 13 down to 17, those set out the relevant statutory provisions of the Criminal Justice Act. And you can see at 13 that section 1.3 confers on the director the power to investigate any suspected offence which appears to him on reasonable grounds to involve serious or complex fraud. And then you can see at paragraph 14, section 2.3, provides that the director may by notice in writing require the person under investigation or any other person to produce at such place as may be specified in the notice any specified documents which appear to the director to relate to any matter relevant to the investigation. Now, and you can see if you just go down the page, paragraph 16, section 2, subsection 13, provides that any person who without reasonable excuse fails to comply with the requirement imposed on him under section 2 shall be guilty of an offence and liable on summary conviction to imprisonment for a term not exceeding 6 months or to a fine or both. Now, then we see, so that's the context in that case, and if you go to page 1261 of the bundle, paragraph 21, you see the heading above that paragraph, the presumption against extraterritorial effect. And the presumption is described, and Lord Bingham's speech, so here the court, Lord Lloyd Jones, refers to Lord Bingham's speech in Alskaney to describe the the presumption. And if you go over the page next to letter B at the side, in the absence of an intention clearly expressed or to be inferred either from its language or from the object or subject matter or history of the enactment, the presumption is that Parliament doesn't design its statutes to operate on its subjects beyond the territorial limits of the United Kingdom. So one's looking at the parliamentary intention, either clearly expressed or to be inferred from language, object, subject matter, or history. And then if you go down to paragraph 23, next to letter H, the strength of the presumption may vary. And so what the court's saying in this particular paragraph is that in particular, it will be considerably diminished or may not apply at all in respect of the state's own nationals. But there are other authorities to show that the strength of the presumption varies more generally according to context. Then paragraph 24, over the page, the presumption is rooted in international law and notions of comity. And we don't dispute, and the very recent Supreme Court judgment in Maroof makes this clear, it's also in the bundle, but we don't dispute that in order for the presumption to apply, there doesn't need to be a breach of international law. It can be rooted in concept, in notions of comity. So you don't need to show, as the court says at paragraph 25, next to letter G, not necessary in invoking the presumption, to demonstrate that the extraterritorial application of the legislation in issue would infringe the sovereignty of another state in violation of international law. You don't need to go that far. And then if we go over the page, paragraph 27, this is under the heading, is the presumption rebutted by the language of the statute? And the court there says the question for consideration is whether Parliament intended to confer on the SFO power to compel a foreign company to produce documents held abroad on pain of a criminal penalty in this jurisdiction. The answer will depend on the wording, purpose and context of the legislation, considered in the light of relevant principles of interpretation and principles of international law and comity. So pausing there, it's a question in all cases of statutory construction, which is context specific. So although one can derive these principles from judgments such as this, that the application of those principles will be context specific in each case and will depend on both the wording and the purpose and context of the statutory scheme. Then at paragraph 28, the SFO, Sir James Eadie for the SFO made the point that the words used in section 2.3 were deliberately wide. And the Supreme Court held, you can see this at letter E, that the breadth of these provisions provides some support for the SFO's case, but then went on to note that in many cases where Parliament is legislating extraterritorially, they'll make that clear expressly. And there was no clear provision here either way. And then at 29, an intention on the part of Parliament to give extraterritorial effect to a statutory provision may also be implied inter alia from the scheme, context and subject matter of the jurisdiction. And they referred to Bilter. But the court was in this case unable to find any clear indication for either for or against extraterritorial effect in the other provisions of the Act. Now, one of the points made by Lord Pannick for KBR, we can see at paragraph, on the next page, we can see that they relied on, this is at the top of the next page, next to letter B, Lord Pannick relies on sections 2, 4 and 5 of the 1987 Act, which provide that where a person's failed to comply with an obligation under section 2 to produce any documents, a justice of the peace may issue a warrant. And this really goes to the point that my Lord Green was putting to me, where I said I didn't want to overstate the position, because what the court says, if you look at letter C, is that this may provide some support for the submission of KBR. So what was being said was, well, that obviously can't happen abroad. Therefore, Parliament can't have intended this to be extraterritorial. But what the court held is that this provides some support for the submission of KBR. However, while the intention behind a provision in a statute needs to be ascertained by looking at the statute as a whole, it doesn't follow that all provisions in a statute have the same territorial ambit. Sections 2, 4 and 5 do not necessarily prevent the extraterritorial application of section 2.3, notwithstanding the fact that the enforcement procedure for which they provide would not be available. And I think that does go directly to the point that was being put to me by my Lord Justice Green.
Yeah.
Now, if we then turn on, please, to paragraph 31 over the page, the court there says that there's greater force in a further submission on behalf of the SFO. It's clear that an intention to give a statute extraterritorial effect may be implied if the purpose of the legislation could not effectually be achieved without such effect. Now, that's very important in our case for the reasons that we've really canvassed already in discussion. But then the court says at 32, the question whether such a purposive reading is capable of rebutting the presumption against extraterritorial application will depend on the provisions, purpose and context of the particular statute. It also requires consideration of the legislative history of the statute and whether Parliament can be taken to have intended that the purpose of the legislation be achieved by other means, matters to which I now turn. Now, this is really an important section of the judgment in my respectful submission, because what we then see is that the critical factor which led the Supreme Court to determine that the presumption against extraterritoriality was not rebutted in this case was the fact that the legislative history of the Criminal Justice Act demonstrated that Parliament's intention was that evidence from abroad should be obtained through reciprocal international arrangements. So there were detailed other arrangements for obtaining this information. And in those circumstances, it's not surprising that the court held, well, the existence of all of those detailed alternative mechanisms of international cooperation doesn't sit easily with interpreting Section 2.3 in an extraterritorial way. But in contradistinction to that case, the investigatory powers in the Competition Act are the only powers that the CMA has to obtain information. Now, my learned friends say, oh, well, they can ask, but that's really a hopeless submission because, as the court will well know, there are very strict safeguards on the sharing of information received by competition authorities, safeguards relating to confidentiality. And there simply is no obligation on foreign competition authorities to provide this information to the CMA. So we're in a very different world to KBR. And we can see that by the features of the legislation in that case, on which the court placed weight. So if you turn on, please, a couple of pages to paragraph 36. So a backdrop to the Criminal Justice Act was the Roskell report. And if you look at paragraph 36, nothing in the Roskell report which recommends the creation of a statutory power which would permit UK authorities unilaterally to compel, under threat of criminal sanction, the production in this country of documents held out of the jurisdiction by a foreign company. On the contrary, it emphasises the importance of establishing reciprocal arrangements for obtaining evidence from abroad. And then if we go to 38, look at the first sentence. The Criminal Justice Bill contained a clause which provided a court procedure for requesting the assistance of foreign courts in obtaining evidence from abroad. And then if we go to paragraph 39 at C, so that's looking at section 29 of the Criminal Justice Act 1988, the court says at C, it provides an indication that Parliament intended that evidence should be secured from abroad by international cooperation as envisaged in the Roskell report. Not easy to reconcile this approach with the SFO's submission that section 2.3 of the 1987 Act confers a power whereby a UK authority could unilaterally compel, under threat of criminal sanction, the production here of documents held abroad by a foreign company. Paragraph 40 refers to subsequent legislation. The statutory scheme which permits the UK's participation in international cooperation in this field was extended by Parliament. The enactment of these successive provisions provides support for the view that Parliament didn't intend these powers, operating through reciprocal cooperation with foreign authorities, to sit alongside a unilateral power in section 23. Then we have at paragraph 41, the Criminal Justice International Cooperation Act 1990 stated in its long title that it's an act to enable the United Kingdom to cooperate with other countries in criminal proceedings and investigations. It put in place a comprehensive domestic regime for international mutual legal assistance in criminal matters. Its enactment enabled the UK to ratify the European Convention on Mutual Assistance in Criminal Matters 1959 and to implement the Commonwealth Scheme relating to mutual assistance in criminal matters 1986, and so on. And then if we go over the page to 42, I'm not going to read these out, but 42 to 44, yet further indications in the statutory scheme that evidence is to be obtained through these mechanisms of cooperation. And then 45, the court said this: I've referred to this legislative history in some detail because it supports KBR Inc.'s case. It can be seen that successive acts of Parliament have developed the structures in domestic law which permit the United Kingdom to participate in international systems of mutual legal assistance in relation to both criminal proceedings and investigations. Of critical importance to the functioning of this international system are the safeguards and protections enacted by the legislation, including the regulation of the uses to which documentary evidence might be put and provision for its return. These provisions are fundamental to the mutual respect and comity on which the system is founded. It's to my mind inherently improbable that Parliament should have refined this machinery as it did, while intending to leave in place a parallel system for obtaining evidence from abroad, which could operate on the unilateral demand of the SFO, without any recourse to the courts or authorities of the state where the evidence was located, and without the protection of any of the safeguards put in place under the scheme of mutual legal assistance. So pausing there, as I say, that's an important point of distinction with the present case, because in the present case, the only means the CMA has of investigating breaches of the Competition Act committed by entities abroad are the investigatory powers in the Act, including notably Section 26. Then we see at 46 judicial decisions concerning the effect of different statutory provisions may be instructed by way of analogy, but they need to be approached with caution because they're concerned with entirely different statutory schemes. And that really is, I'm not going to take you to many authorities, and that's really why one gains the principles from the authorities, but really it is, there's no substitute for a close analysis of the terms of this particular Act. We see then a discussion of the Jimenez case, where the court found that the provisions in that case did have extraterritorial effect. And then we have a discussion of some other cases. I think I've skipped over Perry, sorry, 53, that's a point, that's a case that went in the other direction, so no extraterritorial effect. And we've got Jimenez, paragraph 58 does have extraterritorial effect. Then we have at paragraph 60, the Insolvency Act cases, where in a series of cases, various provisions of the Insolvency Act have been held to have extraterritorial effect, and the court distinguished these on the basis set out here. Again, that none of the factual findings or none of the points of distinction call into question the need for a purposive construction of the provisions in hand. And then if we go to, if I can just show you finally on the final pages, paragraphs 64 and 65, what these paragraphs are saying is that any limitation, any territorial limitation implied as a result of the presumption against extraterritoriality must be clear and must be a legitimate exercise of statutory interpretation. So the presumption can't give rise to modification of the statute under the guise of interpretation. And we see that particularly if you go to the final paragraph next to letter B, a statutory rule, thirdly, a statutory rule which empowers the SFO to demand the production of documents by foreigners outside the jurisdiction when there's sufficient connection between the addressee and the jurisdiction without defining what would constitute such a connection would be inherently uncertain. And as I'm going to come on to show you when we look at the judgment, we say that that's a trap the tribunal fell into in this case. It did, we say, rewrite the statute in a way that's inherently uncertain. So, my lords, that's KBR. I want to take you next to RVL, which is in the first authorities bundle, behind tab 38. Now, before we get into this, the reason I'm taking the court to this case at the outset it is because it's an important part of the respondent's argument that an undertaking is an artificial construct which is not equivalent to a legal person, and therefore one has to read any person in section 26 as excluding an undertaking. So they say an undertaking is an artificial construct. It doesn't take steps which are legally binding. It can't have things done to it which are legally binding. Therefore, that's why you've got to read section 26 contrary to section 59 in a way which excludes undertaking. And what RVL is an illustration of, and we say it's really a basic proposition, is the fact that Parliament can decide what entities it deems to be persons which can take legal steps or have legal steps done to them. And the true position is that as a sovereign legislature, Parliament can deem any entity it likes to be a person. And indeed, in the very first line of his speech in the seminal case on corporate personality, Salomon and Salomon, Lord Halsbury famously called limited liability companies an artificial creation of the legislature. This is a point which in a sense is a trite point, but it does go to the heart of my learned friend's argument. Now, this authority is about whether an unincorporated association, which in that case was a golf club, could be liable for a criminal offence. And it's an interesting analogy because, of course, unincorporated associations are often said to have no legal personality, which is really the argument that the respondents are running here in respect of undertakings. And that's, of course, true in the sense that they can't contract, but you may have seen that the definition of person in the 1978 Interpretation Act includes unincorporated associations. And Section 5 of that Act provides that the definitions shall apply unless the contrary intention appears. So the question in this case was whether an unincorporated association, the golf club, could be liable under the Water Resources Act for causing pollution to enter a local waterway. There was then a secondary question, which was whether the officers of the club could also be liable. And the Court of Appeal gave a single judgment. And if we can turn to page 630 of the bundle and look at paragraph 4, that just sets out...
Well, it was the Court of Appeal Criminal Division, so it's
So
always
it
a
would
single
give a-
judgment.
My lord, that's quite right, yes.
You're not
Yeah.
allowed to dissent.
Not allowed to dissent.
No, the strictures of the Court of Appeal Criminal Division. Yes, so necessarily a single judgment, so I'm not going to read anything into that at all. So paragraph 630, top of the page, that sets out the offence. So a person contravenes this section if he causes or knowingly permits any poisonous, noxious or polluting matter to enter any controlled water. So a person. And if we look at paragraph, if we go to page 631, the next page, we can see paragraphs 12 to 15 are addressing the issue of legal personality. So paragraph 12 explains that at common law an unincorporated association is to be distinguished from a corporation which has a legal personality. But then 13, this is an apparently simple legal dichotomy, but its simplicity is deceptive. And then we see that 14, many unincorporated associations have in reality a substantial existence. And then at 15, as to the law, it no longer treats every unincorporated association as simply a collective expression for its members, and has not done so for well over 100 years. And then if we go to the court then turns to the Interpretation Act, and you'll see from paragraph 18, so on page 632, that the judge's conclusion that the club could be liable for the criminal offence rested on definition of person in the Interpretation Act. And there's then the question, and we see that at paragraph 20, the argument before us has revolved correctly around the question whether in reading section 85 of the 1991 Act, the contrary intention appears within the meaning of section 5 of the 1978 Act. So that was the question before the court, and you can see the Crown's argument at paragraph 21. So the Crown said that the 1991 Act demonstrates such a contrary intention, viz. That person does not include an unincorporated association because the Act does not contain a specific provision making such an association criminally responsible in its own name. In the absence of such a specific provision, says the Crown, the ordinary common law principle that an unincorporated association is no more than a collective noun for its members must prevail. There are, it's suggested, too many practical difficulties in the judge's decision to the contrary. So again, echoes of the respondents' arguments here. In particular, this Act does not, we're reminded, contain any provision for adapting the procedure of the courts to a non-natural person. So there would be difficulties, it's suggested, in taking a plea or in committing the association to the Crown Court for trial or an enforcement of a penalty if convicted. So again, echoes of the points that the respondents are making in this case. There's then a discussion of various other cases in which criminal statutes were held to apply to unincorporated associations. And in those cases, there were particular clues, if you like, in the statute which showed that Parliament intended the offence to apply to such association. And you can see at paragraph 24 a flavour of those clues, but there were no such clues in the present case. All there was the definition in the Interpretation Act where person includes unincorporated association. But what we see from paragraph 29 is that the absence of such clues did not mean that the Act should not be given its ordinary meaning. And if we go to page 636, please, letter B, whether or not it be true that the presence of differing kinds of statutory provision in some acts has inhibited the prosecution of unincorporated associations in their absence. The definition in the 1978 Act is of general application. That's in the 1978 Interpretation Act. And of course, in this case, we're a fortiori because Section 59 is in the very same statute. To assert that a contrary intention appears from the absence of a specific statutory provision amounts to depriving that definition of its generality. We conclude that the judge was right in his first decision. The prosecution of the club was permissible in law. The definition of person in the 1978 Act applied, and no contrary intention appeared. So the court gave effect to the statutory language, and whilst unincorporated associations don't have legal personality for many purposes, whereas here Parliament has said that they are persons, and the criminal offence applies to a person, they can indeed be prosecuted. And what we take from this for our context is that where Parliament has said that an undertaking is a person, we must give effect to that. Now, it is of course true that undertakings tend to consist of other legal persons, most commonly companies. But again, one could say the same of other legal fictions. So a person under the 1978 Act includes, to quote the Act, a body of persons corporate or unincorporate. So in other words, most incorporated companies are just a group of persons, but when one's talking about obligations on a company, one doesn't worry about those other persons. The company is seen as the unit of account, and that's the same with undertaking. So where there are obligations on an undertaking, imposed on an undertaking, they apply to the undertaking as a whole, and they're not limited or curtailed by reference to the other persons which comprise the undertaking. That's really our point in this case. Now, finally, by way of framing authorities, I'm going to take the court to Arlberg, Portland, and that's in the third bundle of authorities, behind tab 71, Judgment of the European Court. And this judgment shows, as I indicated earlier, that the Commission can compel undertakings to provide documents and information, and it also explains the importance of this power. And can we pick it up, please, from bundle page 1721? and paragraph
Sorry,
50.
1721
of the bundle, 342 of the internal numbering. It's at paragraph 53. And this gives context to the important power to obtain information and documents. So 53, participation by an undertaking in anti-competitive practices and agreements constitutes an economic infringement designed to maximise its profits, generally by an intentional limitation of supply, an artificial division of the market, and an artificial increase in prices. The effect of such agreements or of such practices is to restrict free competition and to prevent the attainment of the common market, in particular by hindering intra-community trade. Such harmful effects are passed directly on to consumers in terms of increased prices and reduced diversity of supply. Where an anti-competitive practice or agreement is adopted in the cement sector, the entire construction and housing sector and the real estate market suffer such effects. The aim of the powers given to the Commission by Regulation 17 is to enable it to carry out its duty under Article 85 under the treaty of ensuring that the rules on competition are applied in the common market. As may be seen from the preceding paragraph, it is consistent with the general interest to avoid anti-competitive practices and agreements, to discover them and to impose sanctions. So that's why we have investigatory powers. It's trite, but here the court is explaining it. Since the prohibition on participating in anti-competitive agreements and the penalties which offenders may incur are well known, it's normal for the activities which those practices and those agreements entail to take place in a clandestine fashion, for meetings to be held in secret, most frequently in a non-member country, and for the associated documentation to be reduced to a minimum. So here, the court's recognising that one of the ways that infringers of the competition rules have tried to evade the detection is precisely by carrying out the anti-competitive conduct outside the jurisdiction. So the regulator is faced with difficulties from the outset in investigating these infringements. That's what the court is saying. And then if we go to paragraph 59, it's appropriate in that context to observe that Article 85 of the treaty refers to the activities of undertakings. For that provision to apply, a change in the legal form and name of an undertaking doesn't necessarily have the effect of creating a new undertaking free of liability for the anti-competitive behaviour of its predecessor, when from an economic point of view, the two are identical. Then at 60, this is a point of distinction, of contrast to the Competition Act. However, the statement of objections must specify unequivocally the legal person on whom fines may be imposed and be addressed to that person. Now that's different, as I'll show you, under the Competition Act. It's different, and the reason why the SO and the decision in EU law has to be addressed to a legal person is because under what's now Article 296 of the TFEU, legal acts must be addressed to persons. Now, there's no equivalent in the Competition Act. I'm going to come back to that point when we look at the Act. But paragraph 61, in order to ensure the effectiveness of the investigative power conferred on it by Article 11 of Regulation 17, the Commission is entitled to compel an undertaking, if necessary by adopting a decision, to provide all necessary information concerning such facts as may be known to it, and to disclose to it, if necessary, such documents relating thereto as are in that undertaking's possession, even if the latter may be used to establish against it or another undertaking the existence of anti-competitive conduct. And so it's plain as a pikestaff that under EU law, the position under Regulation 17 and now under Regulation 1 of 2003, as I'll show you, is that contrary to the submissions of the respondents in this case, requests for information and documents can be made of the undertaking itself, relating to the information and documents within the undertaking's possession, and the undertaking to be deemed as a unit. Now we see this in, that was an older case relating to Regulation 17. Just to show you the updated provision, it's in the same bundle under Regulation 1 of 2003, behind tab 67. And it's Article 18, if we go to page 1434 of the bundle.
Just give us the tab number, it's different bundles for us.
Oh, I'm so sorry. So it's tab 67. if you could tell us where your tabs, I could try and work it out as I go along. If you could tell us where your bundle 3 starts, then
70 is the last one in bundle 4. So
Okay,
the one
I'll
you
try
just
and-
took us to was the first one in bundle 5.
oh, so you've got multiple bundles. I've only got 3.
We've got 5.
5. I think I'm very sorry, that's highly inconvenient. I think I'm gonna have to do it by tabs if somebody could. So it's tab 67.
Example of Lord Justice Sedley's law of documents in cases. Nobody has bundles which, council's got different bundles to the judges.
It's very
Normally,
annoying.
if we have electronic bundles, they never have the same page numbers as the documentary bundles. They're always out of sync.
I know, and then one has to try and give 2 lots of bundle references. I'm very sorry, it's really inconvenient.
But so far, both the tab numbers and the page numbers have been the same.
Well, that's
So Lord Justice Sedley's gloomy view isn't quite borne out.
well. Long may that.
Thus
I hope
far,
that
anyway.
thus far exactly.
Plenty of time.
So tab 67.
Okay, this is regulation.
Regulation 1, and so it's. I just want to show you that the position, although the provision is slightly differently drafted to that in Regulation 17, the point remains, the substantive point remains the same. So 18.1, in order to carry out the duties assigned to it by this regulation. Again, I place emphasis on those words. It does echo what the court in Arlberg, Portland said, which is the very purpose of these investigatory powers are to render effective the substantive rules. The Commission may require undertakings and associations of undertakings to provide all necessary information. And you can see it too when sending a simple request for information to an undertaking. So let's be clear about this, what the respondents are arguing for is something different under domestic law. They're saying well, you can't do that under domestic law to an undertaking. You've got to, section 26 only applies to companies and individuals. Now, I did say at the outset, and I said I'd make this good, and this goes to Miss Abraham's point, which I think Mr. Kennelly is also taking, that what the Commission frequently does is sends information requests to an EU subsidiary, so to that part of the undertaking which is located in the EU, requesting the subsidiary to provide information relating to the entire undertaking, i.e. including those parts which are outside the EU. And we've referred to various indications or authorities in support of this in our skeleton. Let me just take you briefly to a couple, since it seems to be in dispute. So if we go to tab 79, which is probably in your bundle 5.
So are we moving away from the 3 authorities and before we get to the Act, we're now looking at some others?
Yes, so we are, my lord. It's not really, they're points which follow on from Arlberg, Portland, and I thought I'd just wrap them up now, rather than come back to them, because they are.
Have you finished with Regulation 1 2000?
I have.
Just whilst we're on that, I'm just looking at the different powers and requests. So Article 18 can be applied to undertakings.
The power to take statements can only be exercised against a natural or legal person without compulsion.
Yes.
So you can't talk to them. And then powers of inspection are applicable to undertakings.
Yes, and my lord, that's that's interesting, and we say important because again, when one looks at powers of inspection relating to undertakings, obviously the EU legislature is also proceeding on the basis that legal steps can be taken in respect of an undertaking.
Yes. And it makes a deliberate choice as to whether or not you apply against the undertaking or by the very nature of what you're trying to do, for example, an interview,
Yes,
a natural or legal person.
Yes, exactly.
Absent compulsion.
exactly.
Yeah.
So I was going to tab 79. This is the Commission's contribution to an OECD, to the OECD. And if we go to page 1904, so paragraph 16, the Commission may send RFIs to undertakings located inside and outside of the EEA. In practice, the Commission has so far refrained from enforcing procedural fines or periodic penalty payments on companies outside the EA. To effectively use its investigative powers, the Commission frequently resorts to sending the RFI to an EU subsidiary of the non-EU undertaking, requesting the subsidiary to provide the information on behalf of the entire undertaking, including all connected undertakings such as the ultimate parent company and its subsidiaries. So precisely what the CMA is seeking to do in this case, that's what the Commission says it does there. And then if we go to tab 77, this is a case which was withdrawn, an appeal which was withdrawn. Chi May. The applicants were a UK and Dutch company, and they challenged the Commission's decision on the basis that the Commission lacks investigative powers to compel EU subsidiaries. We see this over the page, at the top of the page, to compel EU subsidiaries to produce documents and to provide information outside the sole custody and control of legal entities located outside the community's jurisdiction. Hence submitted that the Commission erred in law by addressing a formal request for information to the applicants, thereby compelling them to provide documents and information under the sole control and possession of the parent company located outside the EU territory. So of course this is an appeal that was withdrawn, but what it does show is the Commission's practice. And it shows that my learned friends are wrong to say that this is just some sort of voluntary act, because the language is compel. And if that were not clear on the face of that, this authority, if we look at Siderka behind tab 76, please, again, another application, another action that was withdrawn. The Commission had addressed an RFI requiring the addressees of the RFI to pay a penalty in the event of non-compliance, and they'd addressed it to an Italian company known as Dalmine and to Siderka, an Argentinian company. And this makes clear that that a penalty notice was appended, and indeed it appears from this that the Commission was intending to penalise the Argentinian company directly. So that's the practice of the Commission. And it's not just the Commission, so EU member states also address information requests to undertakings. I'm just going to hand up a further authority. This is the ECN directive. Which we sent, I think we sent last night to my learned friends. So this is a directive which had to be implemented post-Brexit, so we're not relying on it directly, but it's indicative of the obligations on EU member states. We're not relying on it directly as an aid to construction of the Act, I should say. And it relates to, it's a directive which seeks to harmonise, well you can see the title, to empower the competition authorities of the member states to be more effective enforcers and to ensure the proper functioning of the internal market. And if we go, please, to Article 8, which is on, it's on page 20 in the top left-hand corner. That says requests for information. Member states shall ensure that national administrative competition authorities may require undertakings and association of undertakings to provide all necessary information. So again, that they're required to ensure that national competition authorities may require undertakings and associations of undertakings to provide all necessary information for the application of Articles 101 and 102. Such requests for information shall be proportionate, etc., etc. National competition authorities shall also be empowered to require any other natural or legal persons to provide information. So it couldn't be clearer that under EU law, national competition authorities and I've missed out a critical bit, I'm told. So the obligation to provide all necessary information covers information which is accessible to such undertakings or associations of undertakings. So accessible to the undertaking as a unit. Now, we've put the German legislation in the bundle, Germany, of course, being the state in which Volkswagen AG and BMW AG are located. And unsurprisingly, given the terms of the ECN directive that I've just shown you, that legislation also provides for the German Competition Authority to make information requests of undertakings and impose penalties on the undertakings if they don't comply, so on the undertaking itself. And again, what's said in the legislation is that it covers information and documents accessible to the undertaking. And of course, as I say, it's no surprise at all that that's what the German legislation provides, given the terms of Article 8 of the ECN. And presumably, although we haven't bottomed out the position for every member state, but if they're implementing the ECN directive properly, all of the member states will have to have similar provisions in their legislation.
Where's the German legislation in the bundle?
Yeah, so it's in the...
Just to be noted. Don't need to look at it.
So it is at the very end, I think, or near the very end, and it's, let me just get the page, I don't...
We only need the tab number.
1987, I'm not sure it's been blessed with a dedicated tab.
It's 87.
88.
Okay,
87.
thank you.
And there's a translation of 88.
So what you have, let me just since we're on it, let me just show you. So if I can do it by page number, so 1985 at the bottom of the page, requests for information, you see the heading, and if you go over the page, to the extent necessary for the purpose of fulfilling the tasks assigned to the Competition Authority under this Act, the Competition Authority may request from undertakings, an association of undertakings, the provision of information and the surrender of documents. The undertakings and association of undertakings shall be obliged to provide the information or surrender the documents within a reasonable period of time. The obligation covers all the information and documents accessible to such undertakings or associations of undertakings. So again, it treats the undertaking as a unit. There's also civil penalties attached to non-compliance with that provision.
It says it's an implementation of Article 8.
It does.
The notion of something being accessible to the undertaker, I think, simply presupposes the existence of a broader principle that whether or not to comply is an internal decision within the group. It's up to the head office to decide that it will provide information, for example, to its subsidiaries so it can be disclosed. So it's accessible to the undertaking in principle. It's an internal decision for that undertaking whether or not to comply. And if it doesn't, then it exposes itself to sanctions.
Yes, exactly. So the undertaking is the unit. One doesn't, for the purposes of the obligation, EU law requires the undertaking as a unit to comply. And if, for example, as you say, my lord, if the undertaking, if the parent company takes the view that X subsidiary is not within the undertaking, then it runs a risk of falling foul of the legislation. It has to take a view as to what's in the undertaking.
From a policy perspective, the regulator or the law just treats that as an internal decision.
An internal decision for the undertaking, subject, of course, to the law, to the legal rules. It's clear that the case law sets out what's meant by undertaking, so that's not at large. No. And the obligation, as I say, is on the undertaking. And so if the undertaking gets it wrong and doesn't search for documents in subsidiary X, and that is properly part of the undertaking, then they risk falling foul of the substantive provision. There's no uncertainty about that, we say. And if there is uncertainty, then of course the head office can liaise with the Competition Authority to work out who is caught. Now, before, just because slightly concerned about doing this, given my Lord Justice Coulson's remark about me moving on from the three authorities, but because it is, and I just do it from our skeleton, but because it really is broadly relevant to the points being made by the court in Aalborg, Portland. It may be convenient now, and again I can pick it up from the skeleton, just to look at to make clear that a key purpose, we see this in the legislative history of the Competition Act, a key purpose of the Competition Act was as the court said in Ardberg, Portland, to strengthen the powers of investigation of the Competition Authority and so as to render effective the prosecution of the substantive provisions. And I think we can take it from our skeleton, core bundle, tab 7, page 59, where we've set out the key parts of the legislative history. And we see that what was said was that the previous powers were inadequate of investigation. We see that in the 1989 DTI white paper. And that the 96 consultation document, the DTI observed that inadequate powers of investigation and the absence of penalties to provide an adequate deterrent have in part contributed to the ineffectiveness of the Restrictive Trade Practices Act in dealing with anti-competitive agreements. It explained that if the new legislation is to operate effectively, a number of objectives must be met, investigatory, including that prohibited agreements must be detected. It's fundamental that they have to be detected. Investigatory powers should therefore not only be comparable to those of the Commission, but strengthened. And then in her foreword to the consultation paper on the August 1997 draft bill, the then President of the Board of Trade stated that the prohibition should be effectively enforced and the DGFT should have suitable strong investigatory powers. The DTI's consultation document identified limited investigatory powers as a weakness of the existing law and indicated that the bill was intended to confer strong investigatory powers. It further stated that the DGFT needed adequate powers of investigation to enable him to enforce the prohibitions. So now I really am going to move on to the terms of the Competition Act.
Is that a convenient moment to have a 5-minute break for transcribers?
It is, my lord, yes.
Shall we do that?
All right.
Section 61, paragraph 61.
It's about the city of
Yeah.
in any full case, there's a very close investigation.
Yeah,
But
I
what he's
got that.
focused on is that these bits have territorial stuff. So in this case, there's reason.
I think they're trying to track the reg,
I think there's the there's the fifth piece that case as well.
yeah, it's just because they go to
As the right, so that's their ears, that's their voice.
So basically,
I think the more listeners, if the point is a strong investigatory.
yeah, you're right.
I think the only, so I agree, we should run to the qualification. This was inserted by regulations made to implement modernisation regulation. The original power was not just did it by reference to the I think likely making it was the Queen's problem. So just saying.
Yeah, exactly. I agree. So we can find it.
Just where the tab that-
tabs end.
Yeah.
Bundle 1 is there.
Yeah.
Like on a just actually, if you've not emailed to me, I just want to see something I can read to see. Shall I give you a piece of paper?
I'll
Thanks.
That's harder than I thought.
Okay. Thank you.
Guys,
I'm going to take the court through the version of the Act in force, which is behind tab 9, but I'll also need to refer to some of the provisions in the version as originally enacted, which is behind tab 8. I think it's probably safe to say that tabs 8 and 9 are in your first authorities bundle. I gather the reason for the difference is that mine is double-sided and yours is single-sided, so something as simple as that. But if we could start with section 2, which is behind tab 9 on page 68.
Section 2, yes.
Section 2, so the prohibition is on undertakings and decisions by associations of undertakings. So subject to section 3, agreements between undertakings, decisions by associations of undertakings or concerted practices which may affect trade within the United Kingdom and have as their object or effect the prevention, restriction or distortion of competition within the United Kingdom are prohibited unless they're exempt in accordance with the provisions of this part. And then, as the court's picked up already, subsection 3, subsection 1 applies only if the agreement, decision or practice is intended to be implemented in the United Kingdom. And so the express terms of Section 2 define its territorial scope, because and they do so by reference to the effect on trade being within the United Kingdom and the object or effect of the prevention or restriction of competition being within the United Kingdom, wherever the agreement or concerted practice takes place, so long as the agreement, decision or practice is or is intended to be implemented in the United Kingdom.
That's the wood pulp.
It's the wood pulp, and it was intended to give effect to wood pulp, my lord, yes.
Which address the whole question of extraterritorial effect.
That's right. I will come back to wood pulp. In fact, let's look
at... government intervene on that point.
Yes, and accepted, the court accepted the UK government's submissions. And let's go to it, but let's just look just before we do at Section 18, which is over the page. Again, that applies to undertakings, and again, the provision defines its territorial scope. Any conduct on the part of one or more undertakings which amounts to the abuse of a dominant position in a market is prohibited if it may affect trade within the United Kingdom. And one only needs to think now of what's going on in terms of the large investigations into the US tech companies by the Commission and by the CMA, where what's being said in those investigations is that those large companies are abusing their dominant position. That's all taking place, or largely taking place in the US, but affecting consumers in the UK and in the EU. Yeah. Let's just look at wood pulp. So if we can divert for a moment from the Act, since my Lord referred to it, and it's behind tab 70. Tab 70. 70.
Wonderful.
Thank you. And if we go to page 1625 of the bundle, and the bottom of the page, paragraph 11, so that sets out the substantive provision. Again, it's the same.
Page
1625 of the bundle, so 940 of the report. Yep. Paragraph 11. You can see the heading, incorrect assessment of the territorial scope of Article 85, and incompatibility of a decision with public international law. That reflects the argument that was being made. And then 11 sets out the terms of Article 85. So again, it applies to agreements which affect trade between member states and have as their object or effect the restriction of competition within the common market. So that defines the territorial scope. It's not framed by reference to where the conduct takes place. Then at 12, it should be noted that the main sources of supply of wood pulp are outside the community, in Canada, the US, Sweden and Finland. Of course, at that point, Sweden and Finland weren't members of the community. Where wood pulp producers, and that market therefore has global dimensions, where wood pulp producers established in those countries sell directly to purchasers established in the community and engage in price competition in order to win orders from those customers, that constitutes competition within the common market. It follows that where those producers concert on the prices to be charged to their customers in the community and put that concertation into effect by selling at prices which are actually coordinated, they're taking place in consultation which has the object and effect of restricting competition within the common market, within the meaning of Article 85. Accordingly, it must be concluded that by applying the competition rules in the treaty in the circumstances of this case to undertakings whose registered offices are situated outside the community, the Commission has not made an incorrect assessment of the territorial scope of Article 85. And there's an argument that that's all contrary to international law, which is rejected. And then at 16, an infringement of Article 85, such as the conclusion of an agreement which has had the effect of restricting competition within the common market, consists of conduct made up of two elements, the formation of the agreement and the implementation thereof. If the applicability of prohibitions laid down under competition law were made to depend on the place where the agreement was formed, the result would obviously be to give undertakings an easy means of evading those prohibitions. Yeah. The decisive fact is therefore the place where it's implemented. And I've shown you already Aalborg, Portland, where the court says very often that's what undertakings try and do, precisely to evade detection. The producers in this case implemented their pricing agreement within the common market. It's immaterial in that respect, and we place emphasis on this, whether or not they had recourse to subsidiaries, agents, sub-agents or branches within the community in order to make their contacts with purchasers within the community. Accordingly, the community's jurisdiction to apply its competition rules to such conduct is covered by the territoriality principle. Now, just pausing there, the reason I say we place emphasis on 17 is because the court there is saying it doesn't make any difference whether the undertaking, which is situated outside the jurisdiction, has any subsidiaries inside the jurisdiction. It's still, if it's implementing its agreement, it's still infringing the provisions of the EU competition rules. And that's important when it comes to looking at our ground 1 and ground 2. That's why our ground 1 says, according to our ground 1, we say any person means any person. And the reason why that's very important for the CMA is because, as the court said here, it doesn't matter whether or not an undertaking which is situated outside the jurisdiction and which is breaching the rules and implementing that breach into the jurisdiction, shouldn't matter whether or not they have a subsidiary in the jurisdiction or not. The impact in terms of the distortion of competition within the jurisdiction and the impact on consumers is the same. And so that's why we say we're right on ground 1 as well as ground 2, that any person means any person, because...
So even if these two German car manufacturers did not have UK subsidiaries at all, didn't have any corporate presence within the UK, but were selling into the UK from Germany, you would say that that you could have served a Section 26 notice?
We do, that's our ground 1.
If the conditions of Sections 25 and 26 were satisfied.
Precisely so, my lord, and one can see why that's so, because in a sense it's a matter of...
Precisely the point in paragraph 17.
Yes, exactly.
This is your so-called muscular interpretation.
I'm not going to call it a muscular interpretation, I'm going to call it a logical, purposive interpretation that gives effect to the competition rules, my lord, but yes, it's what the tribunal called the muscular interpretation. And
Your opponents would probably call it the vascular.
they'll call it, no doubt they'll call it all sorts of things. And now, just while we're on this point, let me just show you the consultation paper published in 1996. So that's tab 19. And could you please turn to page 207, because there you see the purpose of the consultation at paragraph 1.8. I'll just ask you briefly to read that yourselves, but you can see that the government's policy is to adopt a prohibition of anti-competitive agreements based on the model of Article 85.
Sorry, which paragraph is it?
1.8, my lord. And
There's a debate as to the evidential value of consultation papers, because of course they're not explanatory material or material from Parliamentary Council. They're quite early in the legislative stage. I don't think there's any dispute that the Competition Act was intended to be an image of EU competition.
no, and I don't think there's any dispute about that. And if I just show you on page 216, jurisdiction, so paragraph 2.48, the government considered in the white paper the appropriate jurisdictional reach for the UK prohibition. It acknowledged then that while the proposed new regime involved a prohibition drawn in terms of effects, that didn't mean that the jurisdiction should necessarily depart from the principle of territoriality and follow the so-called effects doctrine. It recognised, however, that the place where an agreement is made is not always the determining factor. The government believes, therefore, that the prohibition should apply not only to agreements made in the UK, but also to those implemented within the UK. Enforcement will be against businesses established in the UK or against UK assets of businesses which engaged in a prohibited agreement implemented in the UK. So 2 points here. One is that this is evidence that the court was, in section 2.3, seeking to give effect to the wood pulp judgment. And the second point relates to the final paragraph, because what's said against me is, oh yes, the Act provides for penalties if section 26 notices are not complied with, and how can you enforce those penalties if the undertaking is situated outside the jurisdiction. And really the point was considered in the legislative history. So you can enforce against an undertaking to the extent to which it has assets in the United Kingdom. Now, if we could go back, please, to the Act, so back to tab 9.
Yeah.
I want to go now to section 59 on page 125. And you'll see that section 59 applies to part 1 of the Act, so 59.1 in this part. And there are a number of definitions. Now, the part is not very extensive of the Act, so it would be, the starting point is it would be odd if definitions which expressly apply to this part did not in fact apply to this part. And then if we go over the page to 126, we can see the definition of person towards the bottom of the page, in addition to the meaning given by the Interpretation Act 1978, includes any undertaking. So that's the specific provision, explicit provision on which we rely. And you'll find the Interpretation Act behind tab 3. And if you go to page 19 of that, please. You see there that this is...
Given that it says in this part, if the real intention was that this definition didn't apply to, let us say, section 26, then one would expect it to say save in the case of section 26.
One would expect that, my lord, yes, one would expect that. And really, the language is quite clear. It says in this part, this is the meaning. It includes, as well as the definition in the...
any section in the part.
It doesn't exclude any section. Now, of course, we accept that if in a particular provision of the part it's absolutely clear in context that it couldn't mean undertaking, well then we accept that that might evince a contrary intention on the part of Parliament. But one has to be jolly careful before finding that, given the express words in section 59. And just to complete the definition, so it says, the reason I'm taking you to the Interpretation Act is because it says, in addition to the meaning in the Interpretation Act, and you see it page 19 behind tab 3, person includes a body of persons corporate or unincorporate. And so the upshot of this is that person in part 1 of the Competition Act includes a body of persons corporate or unincorporate, includes individuals, includes corporations, and includes undertakings. So that's the upshot. Now, just while we're on the Interpretation Act, can I just pick up an error we say that the tribunal made? In a sense, it's a bit of a it's a bit of a subtle point, but we do say it's an error. So if you go to page 13 of the Interpretation Act, Section 5 says, in any act, unless the contrary intention appears, words and expressions listed in Schedule 1 to this act are to be construed according to that schedule. And the tribunal said that Parliament in Section 59 had incorporated Section 5. And we say that's the wrong way of looking at it, because what Section 5 doesn't include any meaning of person. And what Section 59 says is, for this part, person shall mean the meaning of person in the Interpretation Act, which is the meaning in the schedule, plus undertaking. So Section 59 is not incorporated. The tribunal was wrong about that. But we do accept that if there is a clear contrary intention in part 1, that person shouldn't mean undertaking, then it's open to the court to find that the express words of Section 59 are to be disapplied. Now, the respondent's case is that the definition in Section 59 doesn't apply to Section 26. And we say that, as I said, not only does that not only is that inconsistent with the express wording of the Act, but if you go back to Section 59, so we're back to tab 9, page 126,
Yeah.
the court can see higher up the page, in fact at the top of the page, that there's a definition given to document. Document includes information recorded in any form, and information includes estimates and forecasts. And those are definitions which clearly had Section 26 in mind, because that's all about seeking information and documents. And then also...
Well, interestingly, on the point that I just made to you, I see infringement decision, except in section 49C, has the meaning given to section 47A6. So that this section itself deals with exceptions by making them express.
My Lord, it does,
So it's a further
exactly.
indication that it wasn't intended.
My Lord, I agree with that.
Should be limited.
And then if you look, just while, if we look at page 127, 59, 3 and 4, so for the purposes of this Act, the power to require information in relation to information recorded otherwise than in a legible form includes power to require a copy of it in a legible form. And 4, any power conferred on the CMA by this part to require information includes power to require any document which it believes may contain that information. So again, that plainly has section 26 in mind, because that's all about compelling information. So the idea that section 59, which my learned friends in a rather mealy-mouthed way keep describing in their skeletons as a read-across provision, it's not, it's an interpretation provision which squarely applies to section 26.
Yeah.
Now, what the respondents say, as you'll have seen, is that every time person is used in part 1 of the Act, in circumstances where a specific legal step with legal consequences is contemplated, person cannot include undertaking. Can I just show you that in, let's take it from BMW skeleton argument. So that's core bundle tab 9, page 119. So paragraph 65, BMW say the function of the undertaking concept is to delineate the scope of responsibility, and it's true that section 2 and section 18 do apply to undertakings. By contrast, any step with binding legal consequences must be directed at an identifiable legal or natural person within the undertaking, and that's really the springboard for their submission that any person can't include undertaking, contrary to the express words of section 59. And indeed, we see it, if we go over to paragraph 67 of the skeleton, you see that there, since the section 26 notice is a binding step, which requires specific action by its addressee, it must be sent to one or more legal persons. So that's their argument. Of course, that's not, as you've seen, what happens in EU law, and it's contrary to the express wording of the Act. Now,
as a general proposition, in the abstract, do you disagree with it? Because on your analysis, you could send it to a natural or legal person within a subsidiary of the German undertaking, even if they were just innocent implementers or had nothing to do with it, provided they were within the undertaking.
so obviously you need to give effective notice to the undertaking, and the CMA has every interest in...
Which you would do via a natural or a legal person.
Usually, or you might leave it at the premises of the undertaking if they have premises. So we don't dispute that as a matter of practicality, in order to bring the notice to the attention of the undertaking, one may well serve it on an entity within the undertaking. Now,
Generally, it gets sent to the lawyers, doesn't it? I mean, if you're sending it to an anonymous organisation, often if you don't know who else to send it to, you send it to someone you know has legal authority to act. I mean, that's a matter of practice rather than...
I think that's a matter of practice rather than construction of the Act, but we would certainly accept that one way of giving a notice to an undertaking would be to serve it on a company within the undertaking, but that doesn't prevent it being an obligation on the undertaking. And really this error is an error which underpins the tribunal's reasoning as well, which I'll come on to. And that's why it's an error which underpinned the tribunal's finding that an undertaking, the concept of an undertaking, needs to go through some process of translation into a natural or legal person. I'll come back to that. But we say that these arguments are inconsistent with multiple provisions of Part 1 of the Act, which make clear that Parliament did indeed contemplate that person could include undertaking in circumstances where specific legal steps with legal consequences are contemplated. The tribunal made linked errors, which I'll come to, that an undertaking can't have offices or premises or be served with documents. And as I'll show you in a moment, those findings are flatly inconsistent with the terms of the Act. If we go to section 22 of the Act, so page 51, can we go to section 22 of the Act as enacted, so behind tab 8? So I want to take the provisions more or less in order. This is a provision that's been repealed. So 22, this provided for a person who thought they might be infringing the Chapter 2 prohibition to ask the Director General of Fair Trading to consider whether or not there was in fact an infringement. And that says that, you can see if you look at 22(4)(c), that directly contemplates the Director General giving notice in writing to the undertaking. And so the idea, as BMW say in their skeleton, well, you can't give notice to an undertaking, you have to slice it up and give notice to a person within it, is just wrong. We can see that there. And you can see at 5b, subsection 5b, that if the director has a reasonable suspicion that information which was provided to him by an undertaking engaging in the conduct was incomplete, false or misleading, etc. So that contemplates that incomplete, false or misleading information might be provided by the undertaking rather than by a company or an individual. If we go back to the Act as in force behind tab 9, and let's go to section 25, which we started talking about on page 71. So the CMA, you can see the power of the CMA to investigate. So power of the CMA to investigate in any of the following cases, that the CMA may conduct an investigation. The first case is where there are reasonable grounds for suspecting there is an agreement which may affect trade within the United Kingdom and has as its object or effect the prevention, restriction or distortion of competition within the United Kingdom. The third case is where there are reasonable grounds for suspecting the Chapter 2 prohibition has been infringed. The fifth case is where there are reasonable grounds for suspecting that at some time in the past there was an agreement which at that time may have affected trade within the United Kingdom and had as its object or effect the prevention, restriction or distortion of competition within the United Kingdom. And so you can see, I think as my Lord Justice Green was putting to me, that section 25 has defined territorial limits itself. So it's expressly contemplating that conduct, wherever it takes place, which affects trade between member states, but which has as its object or effect the prevention, restriction or distortion of competition within the UK, can be investigated.
And that's important because section 26 is an implementation of section 25.
It is. It's section 25, without any of the actual powers the CMA has to conduct the investigation, is completely toothless. It's a dead letter. The CMA can.
Section 25 is extraterritorial.
It is. It is, in its terms, extraterritorial. And so Parliament has turned its mind to the territorial ambit of the investigatory powers. So we're in a different position to KBR, where there was nothing, you'll have seen, nothing either express or indeed implied that gave an indication either way. Now,
but just in terms of KBR, and your point about the symmetry between the prohibition and the investigatory power, section 25(1) empowers the CMA to conduct an investigation. An investigation under section 26 has to be either section 2 or section 18, and the details have to be set out in the notice.
Yes.
And you can only exercise this power if you've got reasonable grounds for suspecting.
Precisely so.
You have symmetry on the terms of section 25 and section 2 and or 18.
My Lord, precisely so. And so really our broad point in terms of construction, if I can sort of just cut to the chase, is that it would be very odd if Parliament had specified substantive prohibitions which in terms have extraterritorial effect, not complete extraterritorial effect, but a defined extraterritorial effect, and if Parliament had expressly specified the investigatory powers of the CMA to investigate and punish breach of those substantive provisions in Section 25, but then decided in Section 26 that those powers could not be used in respect of documents held abroad where those are relevant to the investigation in hand. So where, as here in this case, you saw I took you at the beginning, the CMA suspects that most of the anti-competitive conduct took place in Germany. The idea that Parliament has turned its mind to the territorial scope of the investigatory powers in Section 25, which, as you say, my lord, is symmetrical with the substantive provisions. And then in Section 26 said, oh, well, no, actually we've said that, but we're not going to provide you with any means of exercising that power.
You've got a Padfield explanation in the first few words. For the purpose of an investigation under Section 25. So the purpose of Section 26 is to give effect to Section 25, which on its terms empowers you to investigate extraterritorial provision.
That's quite right. And
to
so
investigate.
Yes, and so if I can put it this way, Section 26 is tethered to Section 25, which is tethered to Section 2 and Section 18. And they have to be interpreted as a whole. Otherwise, to pick up the words of the cases on rebutting the extraterritorial presumption, that an important purpose of the Act would indeed be frustrated.
But you don't even need to talk about the effectiveness because you have
Express words.
I mean, that was when we were thinking about this. We said we've really got to start with statutory language and see whether or not they are symmetrical. So when you've got to follow Section 2 into 25 into 26 and just see precisely what Parliament intended. If there's any doubt or ambiguity, you can start injecting other things. But your starting point has to be what has Parliament set out, and is the regime complete?
My lord, we agree with respect, and what you see here is Parliament turning its mind precisely to the territorial question.
In relation to enforcement.
In relation to enforcement, and these are the only powers to enforce these, to detect, investigate, and punish these prohibitions. It's the CMA that's tasked with doing that. These are the CMA's powers. So that's we say a critical point. So not only would the purpose be frustrated, but the respondent's reading is simply contrary to the express terms of the Act. Now,
You say that's a critical point. That's the point.
it's the point.
If you're right that Section 26 is effectively under the umbrella of Section 25, which is in turn under the umbrella of Section 2, that there's no need to differentiate between the prohibition and the ability to request documents and information. There's no distinction between the two on your case. That's it.
That's it.
That stems from, on your primary case, on the language of the statute.
That's right. Exactly. It turns on the language of the statute. That's really our primary submission. And we say, and you'll be aware, I took you to KBR. The respondents say, oh, well, we rely on the presumption against extraterritoriality.
That's an interpretive.
It's an interpretive question. It's a rule of statutory construction. So the key is to interpret the statute. And what we have here are express words showing that Parliament turned its mind to the scope of the investigatory
It's clearly a
powers.
statute which has limited extraterritorial effect.
It is, exactly, on its express terms.
Express terms.
The bit of the judgment that we puzzled about was 74.4.
Yes, well, we're also very puzzled by that. I will come back to that, but we are puzzled by that too. Let's look at, so really that's the long and short, as my Lord Justice Coulson has put it, in terms of our argument on extraterritoriality. The reason now I'm going to deal with the rest of the provisions, or some of the rest of the provisions of this part, with some care, relates really to the undertaking point, because what's said against me on the undertaking point, as I've said, as I've shown you in my learned friend skeleton, is that undertaking, section 59, has to be disregarded or somehow, disregarded, I think must be their case, if a specific legal step is required, because only individuals or companies can take specific legal steps. Now, if we look at section 25A on page 73, what I want to show you now, to be clear, is why that's not right. So all of the indicators to the contrary. So section 25 1D, where the CMA decides to conduct an investigation, it may publish a notice which may, in particular, identify any undertaking whose activities are being investigated as part of the investigation. So it's the activities of
26 one.
25A on page 73. So given that it's the activities of the undertaking that are being
So the
investigated,
notice will identify the activities of
the undertaking any undertaking whose activities are being investigated. And so given that it's the activities of the undertaking that are being investigated, it makes sense that Parliament conferred a power on the CMA to obtain documents from the undertaking. Now, section 26 over the page, obviously that's the power at issue in this case. I'm going to come back to make submissions on this in light of the other provisions, but essentially you know from what I've said so far what our case is on section 26. I want to go through the other provisions. If we go to section 26A on page 77, power to ask questions, and look at section 26A2, the CMA must give a copy of the notice under subsection 1 to each relevant undertaking. So again, the idea that notices can't be given to undertakings is simply not true. You certainly can't infer from the fact, as my learned friends seek to do, that the fact that a notice must be given to any person in section 26, that it's confined to natural legal persons. That's just wrong. And then if you look at, in the same section, subsection 6, you can see that the Act proceeds on the basis that an undertaking has management, control and employees. And then if we go to section 27, the CMA has power to enter business premises without a warrant. The general rule is that notice has to be given to the occupier of the premises, that's subsection 2. And then you see subsection 3 disapplies the rule where the CMA considers that the premises are occupied by an undertaking under investigation. So plainly, Parliament considered an undertaking could be the occupier of premises. Now the tribunal said, and I'll show you this in the judgment in due course, well that can only refer to a natural person. And we disagree. The section plainly contemplates that an undertaking can occupy premises. And then if we go on to section 28, that provides a power to enter business premises under warrant, and section 28A is power to enter domestic premises under a warrant. But if we skip on to section 29, sorry, I may have a wrong reference here. Let me just give me a moment, please. 28, subsection 9, so on page 86. Yeah, that's it. So subsection 9, so in this section, domestic premises means premises or any part of premises that are used as a dwelling and are premises also used in connection with the affairs of an undertaking or association of undertakings, or the premises where documents relating to the affairs of an undertaking or association of undertakings are kept. And so Parliament obviously thought that you can have documents relating to the affairs of an undertaking. So that supports what we say about an undertaking being a unitary person under section 26. If Parliament thought that documents could relate to the affairs of an undertaking, then it obviously makes sense that it conferred a power to obtain the undertaking's documents under section 26. Now, one of the points made by the respondents is that the CMA's case is undermined by the fact that sections 27 and 28 have a purely domestic scope, they say, in that they can't be taken to confer a power to enter premises abroad. Now, our answer to that point is twofold. We accept, of course, that these provisions don't permit the CMA to enter premises outside the jurisdiction, but that doesn't undermine our argument on section 26, because as Volkswagen accepts, I'll just give you the reference to their skeleton, it's paragraph 53.3, not all provisions of the same statute need to have the same territorial scope, and that was a point made by this court in Jimenez at paragraph 34. The reference, for your note, is tab 54 of the authorities, page 1167. And in any event, the fact that sections 27 to 28 are limited to premises in the UK does not mean that they don't have any extraterritorial effect. If we go to section 27 on page 79, and if you look at 27(5)(e), for example, so take 5 at the bottom of the page, an investigating officer entering any premises under this section may, over the page at E, require any information which is stored in any electronic form and is accessible from the premises, and which the investigating officer considers relates to any matter relevant to the investigation. And so clearly we say this includes electronic documents stored in, for example, the US, if accessible on a server in the premises in the United Kingdom.
Yeah.
Now, going on in the Act to section 30A, that's on page 90, use of statements in prosecution, and I'd ask you please to have a look at subsection 4. So a section 26A statement may not be used in evidence against an undertaking with which the individual who gave the statement has a connection on a prosecution for an offence, unless the prosecution is for an offence under section 44. So this indicates that Parliament considered that criminal proceedings, by analogy with R&L, could be taken against an undertaking for a criminal offence, and that's consistent with as I say, consistent with RL. Parliament has deemed that an undertaking is a person, and here they expressly say that the undertaking may be the subject of a criminal prosecution. And then note subsection 5, which is a provision that I've shown you, similar to a provision I've shown you before. So shows that an undertaking can have management or control and employees. And then if we go on, please, to section 31, page 92, decisions following an investigation. If as a result of an investigation the CMA proposes to make a decision, the CMA must give written notice to the person or persons likely to be affected and give that person or persons an opportunity to make representations. Now, the person or persons likely to be affected may include persons other than the undertaking under investigation, but what the provision doesn't say is that notice under section 31 cannot be given to an undertaking, and we say plainly it could because of section 59. And then if we go forward, please, if we skip to section 32 on page 96, section 32 and 33, these provisions apply where the CMA has made an infringement decision, and it can give to such person or persons as it considers appropriate directions to bring an infringement to an end. And as in the case of section 31, Parliament plainly contemplated that directions might be given to an undertaking who's infringed the provisions, but also to others if appropriate. And I'll make that point good by showing you section 34, which we'll look at now. This is a very important section, enforcement of directions. And this is the provision for the enforcement of directions given by the CMA. And you can see at 1, if a person fails without reasonable excuse to comply with a direction under section 32 or 33, the CMA may apply to the court for an order, A, requiring the defaulter to make good his default within a time specified in the order, or if the direction related to anything to be done in the management or administration of an undertaking, requiring the undertaking or any of its officers to do it. And so person in section 34(1) and in sections 32 and 33 includes an undertaking. We can see that explicitly because of the provision in 34(1)(b). So Parliament's here making clear that the court can grant an order requiring the undertaking to take a step. And 34(2) is a further example of that, if you just have a look at 34(2). And again, this is contrary to what the tribunal held, which is that undertakings can't have officers. That was one of the planks in the tribunal's reasoning.
Yeah.
And then if we go on to 36, penalties. So page 101, on making a decision that an agreement has infringed the Chapter 1 prohibition, the CMA may require an undertaking, which is a party to the agreement, to pay the CMA a penalty in respect of the infringement. On making a decision that conduct has infringed the Chapter 2 prohibition, the CMA may require the undertaking concerned to pay the CMA a penalty in respect of the infringement. So the CMA can require an undertaking, and only an undertaking, to pay a penalty for an infringement. That doesn't say person, that says undertaking. It has no power to impose a penalty on any person other than an undertaking. And if you look at subsection 3, you can see that Parliament considered that an undertaking could have a state of mind because it could act either intentionally or negligently, a point which is confirmed by subsections 4 and 5. Subsection 6 says that notice of a penalty must be in writing, and going back to a point that Lord Justice Green put to me, we agree that the notice needs to be effective, and so that may well be that it's given to or served on a person within the undertaking. And then 7A, you can see that the deterrence. So in fixing a penalty, the CMA must have regard to the desirability of deterring both the undertaking on whom the penalty is imposed and others from committing infringements. So the deterrence is aimed at the undertaking and other undertakings, not at companies or individuals. And then paragraph 30, section 36, subsection 8 over the page. No penalty fixed by the CMA under this section may exceed 10% of the turnover of the undertaking. So that's a well-known provision which limits the penalty by reference to the undertaking's turnover. It clearly doesn't refer to any individual or company within the undertaking. It's looking at the turnover of the undertaking as a whole. That's common ground. And that indicates that the person on whom the penalty is being imposed is the undertaking and not a natural or legal person, because the same word must have the same meaning in the same section. Now, interestingly, in thinking about the Section 26 power, the CMA would be expected when assessing the penalty and when giving effect to this 10% threshold or limit, would be expected to gather information about the turnover of the entire undertaking, and of course not simply corporate bodies located in the UK. So if the respondents were right about the limited scope of Section 26, the CMA would not be able to provide this provision, which is, after all, a provision which is favourable to the respondents. How would the CMA get the information under the statute about the undertaking's turnover? Would the respondents turn around then and say, oh, hang on, BMW AG's turnover is significant, but we can't give you any information in relation to that because it's all held in Germany? It's a nonsense. Now, Section 37 addresses recovery of penalties, and the CMA may recover from the undertaking, you see that there in the middle of the end of subsection 1, may recover from the undertaking as a civil debt due to the CMA any amount payable under the penalty notice which remains outstanding. So Section 37 expressly envisages civil proceedings in debt being taken against the undertaking as such. Now, I've shown you the provisions, I've just been showing you the provisions which deal with the enforcement of Sections 2 and 18. In a case where an infringement is committed by undertakings who are outside of the jurisdiction, then we say that the CMA would be entitled to send an infringement decision, directions and penalty notice to those undertakings. And if there was non-compliance, the CMA would be entitled to bring proceedings against the undertaking under sections 34 or 37, if necessary, with leave of the court to serve out. Now, in the event that the court's orders were not complied with, those orders would be enforceable against the undertaking's assets in the United Kingdom. And we saw that. That's the point I showed you in the 96 consultation paper.
Does that just flow from the words civil debt, so that civil debt then means it falls under the provisions of the White Book and other provisions permitting enforcement in default against assets?
Yes, but
You have to bring proceedings.
Is there anything specific?
yes, you have to bring proceedings in order to enforce the debt.
Yes.
But those proceedings can be served out in accordance with the normal rules of the court.
So you'd, just because, in a sense, the words civil debt just bring into play all the mechanism in domestic law for enforcement of civil claims.
My lord, precisely so, exactly. And the fact that it might be more difficult to enforce this against an undertaking based in the United States, for example, you don't then reason backwards and say, aha, that must mean section 26 is strictly territorial in scope. It's simply wrong-headed reasoning. Now, as I'll now come on to, the enforcement of requests for information work in precisely the same way. And there's nothing, and so when it's said by my learned friends, oh well, it's absurd or unworkable, you can't enforce section 26, non-compliance with section 26 against undertakings outside the jurisdiction, that's hopeless and unworkable. Well, it's a similar mechanism, materially identical mechanism to the mechanism you see here, which is expressly stated to be applicable to undertakings, which can be enforced, obviously, within limits against undertakings which are situated outside the jurisdiction. And so the enforcement of requests for information work in precisely the same way. There's nothing absurd or unworkable about it. And once that's appreciated, that disposes of the respondent's argument that the enforcement provisions relating to section 26 illustrate why it can't have extraterritorial effect. And if we go on to section 40A, which is on page 110, so where the CMA considers that a person has, without reasonable excuse, failed to comply with a requirement imposed on the person under section 26 and so on, it may impose a penalty of such amount as it considers appropriate. And so the CMA's case is that in accordance with section 59, a person includes an undertaking in section 40A, as well as section 26. So person includes an undertaking. It's nothing surprising about that, because we see expressly in relation to the enforcement provisions I just took you to that relate to the final decision, that they precisely contemplate enforcement against the undertaking. But of course, requirements under the relevant provisions may be imposed on persons other than undertakings, including individuals, and for that reason the words are broader. That's why it refers to person rather than just undertaking. And then what you have in section 48A, subsection 9, the very last subsection, is an incorporation of various provisions in the Enterprise Act, which I'll take you to now. That's behind tab 11. So that provides, subsection 9 says that sections 112 to 115 of the Enterprise Act apply in relation to a penalty imposed under subsection 1. And if we go to the Enterprise Act or the relevant provisions, they're behind tab 11. If we pick it up from page 150, please. So section 112 to 115 are incorporated. Looking at 112, the CMA has to give notice of the penalty that's being imposed under section 40A. Subsection 4, the notice shall be given by serving a copy of the notice on the person on whom the penalty was imposed, which can include an undertaking, will come to service in due course. Section 114, if we go on, page 153, creates a right of appeal on the merits against a penalty, a right, of course, which BMW exercised in this case, and that's an important safeguard. And then section 115, recovery of penalties. This provision is materially similar to section 37, which we just looked at, and provides that if a penalty is unpaid, the CMA may recover the penalty as a civil debt. And again, if the CMA wished to bring proceedings against a person outside the UK, leave to serve out would be required and enforcement would likely be against UK assets. Now, you saw earlier that a penalty notice had to be served. The service of documents under the Enterprise Act is dealt with under section 126, and it's well established that provisions of this nature are permissive rather than mandatory. The terms of section 126 in terms permit service outside the United Kingdom. So service of documents, look at 1A, start with 1A, any document required or authorised by virtue of this part to be served on any person may be served by delivering it to him or by leaving it at his proper address or by sending it by post to him at that address. So starting point is proper address. And then if we go to 2A, for the purposes of this section, in its application to this section, the proper address of any person on whom a document is to be served shall be his last known address, except that in the case of service on a body corporate, other than a limited liability partnership or its secretary, it shall be the address of the registered or principal office of the body. Now, so if a foreign company is being served, it may be served either at its registered office, which will be in the country of incorporation, or at its principal office. And if the CMA decides to serve the foreign company at its principal office, we can see from section 126(3) that means principal office in the United Kingdom. But that provision doesn't prevent the CMA, doesn't restrict the ability to serve at the registered office, which may be outside the United Kingdom, because you see expressly that section 126(2)A gives the choice. In the case of service on a body corporate, it shall be the address of the registered or principal office. And then you see at subsection 6, any notice in writing or other document required or authorised by virtue of this part to be served on any person may be served on that person by transmitting the text of the notice by electronic means. And there's no territorial restriction on that, and so service by email abroad is contemplated. So we do say it's significant that when making provision for civil penalties for breach of section 26, Parliament incorporated by reference provisions permitting the service of penalty notices outside the United Kingdom of foreign companies.
Just so I can catch up, you said incorporated by reference. What's the provision in the 1998 Act which brings us in?
It's section 40A, subsection 9, and it incorporates these provisions.
Thank you.
Now, section 40A was introduced by way of an amendment in 2013 in order to make enforcement more effective. I'm not going to turn that up, but we see that from the explanatory notes, paragraph 325, and the reference for that's tab 22 of the authorities, page 241. But I do also need to show you the provision for the enforcement of section 26, which existed in 1998. And those are behind tab 8 at page 59. And so in its original form, section 42 provided that a person is guilty of an offence if he fails to comply with the requirement imposed on him under section 26, 27 or 8. Now, 2 points we make. In accordance with RVL, person here does include undertaking and there's no contrary intention. And we saw from section 30A subsection 4 that Parliament has specifically contemplated criminal proceedings against an undertaking for an offence under section 44. So there's nothing odd about an undertaking being subject to a criminal prosecution in this Act. Parliament's expressly contemplated it in section 30A. And subsection 2 indicates that the power under section 26 is not restricted to documents in the possession or control of the recipient. This reflects a decision I don't need to take you to called re-arrows followed in KBR. You'll then see at subsection 3 the defence of reasonable excuse. That's in subsection 3. Now, can I just ask you to turn up BMW's skeleton argument at this stage? So if we go to the core bundle, tab 9, page 121. And it's paragraphs 71 and 72. Let me just start with 72, which is on page 122. That says, that's the conclusory paragraph. It says, the mismatches identified at paragraph 70 and 71 above between the scope of section 26 on the CMA's case and the scope of the penalty provisions deal a fatal blow to ground 2. That's the submission. But let's look at what BMW mean by the mismatch. The argument's at paragraph 71. And let's go through it. So 71, so they say CMA's case is inconsistent with the statutory drafting on the scope of criminal liability. 71.1, as enacted, section 42.2 provides that if a person is charged with an offence under subsection 1 in respect of a requirement to produce a document, it's a defence for him to prove that the document wasn't in his possession or under his control. And then over the page, 71.2, Parliament's obvious intention was quite straightforwardly that section 26 notice should be directed to a specific person who would have a defence to criminal liability if documents were not in their individual possession or control. Then it said, to achieve what the CMA contends was Parliament's purpose. However, the defence should only have been made available where the documents were not in the possession of any member of the undertaking. The scope of section 42.2 doesn't make sense if the CMA's interpretation of section 26 is correct. The CMA has no answer to the point. But this is, with respect, a bootstraps argument, if ever there was one, because it assumes that it's obvious that the section 26 notice must be given to a company or individual to whom the defences under section 42.2 and 3 would apply. But our case, of course, is that the section 26 notice can be given to an undertaking. And if it's given to an undertaking, the defence is that the defence under section 42 and 43 applies to the undertaking. So if the undertaking is charged with an offence, it's a defence for him to prove that he had a reasonable excuse for failing to comply with the requirement. And that's a defence which is open to the undertaking to take if the documents were not under the undertaking's control. So the so-called fatal argument depends on assuming what the very issue before the court in this case, namely, does section 26 have to be directed to an individual or a company? And we say no. Now, just before I leave these provisions, you can see that there's a further offence of destroying or falsifying documents under section 43 and an offence of providing false or misleading information under section 44. These provisions have not materially changed. And you will have seen earlier from section 22(5)(b) that an undertaking could supply information that was false or misleading, and that's an indication that the undertaking could commit the offence under section 44 as well as under section 42. Then if we go to section 55, still in the original version of the Act, this provision on page 61, this provision has been superseded by Part 9 of the Enterprise Act, but you'll see that it imposes a prohibition on the disclosure of information relating to the business of an undertaking while that business continues to be carried on, subject to the remaining provisions of the section. And so there are important safeguards on information that's collected by the CMA under compulsory statutory powers, as the court will be aware, in terms of confidentiality and so on. But you'll see again that from the express language that Parliament thought that an undertaking could carry on a business. And then if we go forward to section 58, 58(1), unless the court directs otherwise or the director has decided to take further action in accordance with section 16(2) or 24(2), a director's finding which is relevant to an issue arising in part 1 is binding on the parties. And this contemplates, and then you see the definition of relevant party, if you go further down under B, in relation to the Chapter 2 prohibition undertaking whose conduct is alleged to have infringed the prohibition. And so you can see there again that what's contemplated is that the undertaking may bring an appeal. You see that expressly from the words in the provision. Yeah. And then you see section 60 as enacted. That's over the page. That's been superseded following Brexit by section 60A, a provision that the court will be familiar with. Would you like me to take you back to it? I'm sure you know what section 60A provides. It's at tab 9, page 130. Yeah. So that's what I wanted to say about the Act. Now, the respondents have relied on the bill. That's at tab 17. And if I take you, it starts at tab 17. If I can take you to page 192 of the bundle. And their reliance on the bill is flawed for two reasons, we say. The first is that proposed legislation that has not been and may never be enacted by Parliament is not an admissible aid to the construction of a statute that has been enacted by Parliament, so it's an admissibility issue. But secondly, if you go to page 192, you can see the provision that would be inserted into the Competition Act by the bill in its current form. So if you look at the bottom of the page, extraterritorial application of notices under section 26 and 40ZD. This section applies to the exercise of the CMA's power to give a person a notice.
Which sections, Demetria?
This is clause 15. So at the bottom of page 192. This is the provision relied on by my learned friends. They say, oh, this provides for an express extraterritorial power, therefore it must mean existing section 26 doesn't contain one.
Yeah.
But the court will see from new subsection 2 and 3, we'll see there that notice may be given to a person outside the UK in the circumstances specified there. And while our primary position is that it's wrong in principle for the court to attempt to construe draft legislation that hasn't been enacted, the court will see from the new subsection 7 at the bottom of that page, this: nothing in this section is to be taken to limit any other power of the CMA to give a notice under section 26 to a person outside the United Kingdom. Yeah. And so, if this were relevant, it's quite plain that the bill envisages that it may be lawful for the CMA to give such notices as the law stands. And one might think that in circumstances where this bill was introduced after the tribunal's decision, it's important to have a provision in circumstances where the law has been rendered uncertain. So, just to sum up where I am in a couple of minutes.
May not be clear, but is it said that clause 15 was introduced after this decision of the CAT, specifically to deal with it, or
the whole bill was introduced after the decision of the CAT?
But it wasn't in consequence of the decision of the CAT.
I don't think I can go so far as to say it's in consequence. I simply can't help the court on that. But essentially we say that it makes clear on its face that it's without prejudice to any existing power under section 26 to serve outside the jurisdiction. And I think
so
it's...
if your point there is that sub clause 7 is preserving whatever the law is as it stands, and if you're right about the law as it stands, well that's a complete answer to reliance on this provision.
Precisely so, my lord, yes. Now, in the sort of 1 or so minutes, can I just take stock, because I'm at the end of going through the Act, and just take stock, returning to section 26 to try and wrap up what we say about section 26. So we say that the express definition in section 59 applies to section 26, as it does to all of part 1, such that any person includes undertaking. This part of the Act is relatively short. Section 59 is clear and on its own terms plainly contemplates it will apply to Section 26. There is no indication in the Act that Parliament had any contrary intention. Any such contrary intention would need to be clear. The respondents seek to derive a contrary intention from their argument that an undertaking is an artificial construct, and in their words, no specific step can be taken by or in respect of an undertaking. So they say where the statute envisages a specific step, person must mean a corporation or individual. But that submission, as I've shown you, is flatly inconsistent with the express terms of the Act. As I've shown you, Parliament has indeed provided that an undertaking can take specific steps with legal consequences or have specific steps taken in respect of it. Parliament's chosen to provide that an undertaking is a person for this part of the Act. It's obviously open to Parliament to do this, see R&L. Another recent example, not in the bundle, but one which my Lord the Chancellor will be familiar with, is Mintz and PJSC National Bank Trust, where the Court of Appeal noted that Section 9(5) of the Sanctions and Anti-Money Laundering Act 2018, which is in the bundle incidentally, provides a clear extension to the definition of person. Parliament can certainly decide what it wants in terms of who's to be defined as a person for the legislation in hand. So there's no...
Whether we get to mints at some point.
We can provide you with copies if necessary. I don't think it's necessary because I think the actual proposition is well established that Parliament can decide to do that. I've taken you to R&L.
That is clear.
And so there is no support for the respondent's submission in the Act itself. And importantly, and I do emphasise this, what the respondents have singularly failed to do is to point to any reference to person in Part 1 of the Act, which on their case would include an undertaking as required by Section 59. And so on their case, Section 59 is a dead letter. So if that's a convenient place to stop, then I've got to the end of the Act. What I propose to do after the lunchtime adjournment is to take you to the judgment below and then really draw together the threads of my submissions, which I hope I can do quite shortly given the discussion that we've been having.
2 o'clock then, please.
All rise.